With the basics of a common law legal system out of the way, we're going to go a bit deeper now and narrower into the Australian legal system. First, we're going to touch off on the basics of the Australian legal system and the key principles behind it, including the Constitution. Then, when we've done that, we'll go into the three key arms of government. So why don't we get started? So the first point to note is that Australia is in fact a federation of states. Okay, so we're governed overarchingly by a federal or Commonwealth government that's in Canberra. So Canberra is the capital city of Australia. We have 6 states, Queensland, New South Wales, South Australia, Tasmania, Victoria and Western Australia, and 2 territories, the Northern Territory and the Australian Capital Territory. And each of those states and territories has its own government. Some aspects of business law are regulated by the federal government, some by state government, and some by a combination of both. We're going to find out that the main determinant of which government governs the area of law is the Australian Constitution, right, as interpreted by the High Court. So the Australian Constitution is a form of legislation, and then it gets interpreted by the High Court, the judiciary, because we're in a common law system. But before we get into that, we want to have a look at the hallmarks of Australian government. So there are 6 key attributes that we're going to go through in terms of Australia's legal system. The first one is that we're a liberal democracy, so we're a representative democracy where we vote for the people who are in Parliament. Laws are made by elected representatives, and the actual executive government consists of elected executives as well. They exercise that power subject to the rule of law, so subject to the judiciary and the rules that are set out in our law. So they can't do whatever they want. They're subject to the rule of law, and particularly the aspect of law that they're governed by the various federal and state constitutions. The second thing that we're going to mention is that we have a common law system based upon the British legal system, and we spent most of those previous few videos looking at that common law legal system. Really interestingly, Australia is a constitutional monarchy. That means our head of state, both at the Commonwealth or federal level, at the Australian level, and at the state level, the head of state is the King or Queen of England. So at the moment, it's the Queen, right? Queen Elizabeth is our head of state. But within the government, they have a representative here in Australia. That representative in the federal government, right? So that's at the national level, at the Australian level, the representative of the Queen is the Governor General. At the state level, it's the governor. Okay, so there's just a small difference in terminology there about the representative of the Queen. Now, of course, we also know from the previous vodcasts that we were doing that the Queen doesn't have a lot of power these days, nor do their representatives. Technically, we'll get into it, that a bill doesn't become a law, so the law doesn't come into power until it receives royal assent. So that representative has to sign it. So it's still important from our legal process, but there's not a lot of discretion, or there's not a lot of decision-making power for that individual. They operate far more for when there might be really bad problems in the system that can't get resolved, and we need someone to kind of break a deadlock, for instance. They're the kinds of situations where that individual steps in. Other than that, the role is largely ceremonial. They do a lot of, for instance, charity work, being a patron, and it's a symbolic role that's there just in case we need it, is probably the best way to think about it. Now, as we've mentioned, Australia is a federation. Okay, so what that means is that the states came together. Well, actually, they were colonies at the time. They came together and became states under the federation. They're not, this is really important, they're not subordinate to the federal government. It's rather that power is shared between them, and different power in different areas is shared between them according to the Constitution. Okay, so it's a classic point. We are a federation of states and territories. We're going to come back to the separation of powers. That's an important doctrine that we want to go through and make sure we have a conceptual understanding of. The other important aspect that we want to cover off on is this principle of responsible government. So there's a bit of a trade-off between separation of powers and having a responsible government, something that we'll come back to when we do separation of powers and we compare the Australian system to, say, the US system. But in essence, the executive government, okay, so the government that actually puts the plans into action, puts the laws into action, is called the executive. So the people who run the executive are called the ministers. Now, the ministers are actually elected in Australia. Okay. Now, they're elected, which then means that they also report back to all the other elected members, to the other people in the legislature. So that means that the ministers and the government that's putting the plans into action is responsible to the Parliament. Ultimately, the executive are answerable to the citizens through Parliament. And that's what we mean by responsible government. So if there isn't a mechanism to hold the executive of government to account, then we don't have responsible government. But we have that in Australia through the ministry and the structure of our executive, which we'll get to in a couple of videos. So one of the topics that I skipped over in those 6 attributes of the Australian legal system was this separation of powers. It's not just Australia that has a separation of powers. In fact, most other democracies have some form of the separation of powers. The basic idea here is that you don't want a single person or a single arm of government to have absolute power. What you want are checks and balances, that one part of government checks on the other. And we do that by separating three key bits of government. First, the legislature, the people who make the law. Second, the executive, the people who administer the law or put it into action. Third, the judiciary, those who judge the law or decide what the law actually says. And the separation of powers says those 3 functions should not be carried out by the same person. Why? Because that would lead to a dictatorship. If one person could write the law, administer it, and judge it, they could actually just do whatever they want. If they didn't like the way they wrote it, they would just reinterpret it how they wanted. So by having these separation of powers, what we get is a greater and stronger democracy and less likelihood of tyranny, with no one being able to control the entire government. So the separation of powers refers to the distinction or separation between the power to make law, administer law, and interpret law. The difference between the legislature, the executive, and the judiciary. So some basic terminology around the legislature. The legislature is given the power to make the law. That in Australia is the federal parliament and the state and territory parliaments. So just next door to QUT here is the state parliament where they make state laws. Parliament is a body of elected representatives, and we'll go into how we elect them and what that means, but they're elected by the people and they make the laws, which we call legislation. We also call them statutes or acts of parliament. The executive administers the law. They actually carry on the business of government and maintain order and security and make sure that the laws are put in place. In Australia, the executive consists at the federal level of the Prime Minister and the other ministers, so the ministry. In the state governments, it's the Premier and the other ministers who form the executive. So the executive in the Australian system is a subset of the legislature. They undertake the day-to-day governance or the day-to-day running of the state. Judicial power is exercised by the courts, which is an entirely separate organ of government. So as we've mentioned, the doctrine of the separation of powers is the notion that these three, the legislature, the executive, and the judiciary, should as far as possible be functionally separate. So the same person shouldn't form part of more than one of them. One arm of government should not control or interfere with the other. One arm should not exercise a function of another. So we see that most strictly in the US, where the legislature, Congress, is separate from the executive, who is cabinet and the secretaries of state, and they're separate from the judiciary, the Supreme Court. However, in Australia, we do not have a strict separation of powers. In fact, our executive is a subset of our parliament or our legislature. We do have a strict separation of our judiciary. Now, you might ask, why? Why don't we have this strict separation? If we go back to this idea of responsible government, one of the other hallmarks of Australian government is that the executive should be reporting to the people, and they do that through Parliament. So by drawing the ministry out of Parliament as a subset of Parliament, what we find is that when things go wrong in a government department, the people running that department have to turn up to Parliament and ask questions from other people in Parliament. So under the Australian situation, we might consider them more responsible, more accountable for what's going on. We do, however, enforce this strict separation of the judiciary from the executive and the legislature. So that gives us a kind of basic outline of the Australian legal system. We have, for want of a better term, a couple of levels of government, the state and territory level, the federal level. Within both of those levels of government, we have a legislature that makes law, an executive that administers law, and a judiciary that interprets and or judges the law. What we're now going to do is to look at how do we decide which part of government decides what laws. And to do that, we have to get into how Australia came together as a nation and how we implemented that coming together in the Constitution.